know how, I mean, it's very difficult to curb a situation of an abstract form of a discrimination where the law becomes helpless at times. Then the innovative ideas and the innovative thinking of the law courts, especially of the superior jurisdiction, is, I think, it can be of a great, I mean, it can be of great assistance to the while administration of justice. It can be of great assistance in giving a direction to the society, because sometimes I do come across, the courts these days are becoming very, very proactive. They are they discuss, they decide according to their philosophy. I think that becomes a compulsion, not merely of a particular situation, but when you confront in a situation that this ailment is in the society, then you have to deal with not merely to treat that individual discriminatory form of injustice, but also to think as to give a as to think in what way, in what manner you can give a direction so that we keep a check on such imbalance in society in spite of plethora of laws, in spite of the constitutional values. That, I think, is always a difficult task. But I think maybe as a so I hope I have not tried to encroach on the time of the speaker, because the judge in me at times prompted me to speak more than required. So because this was a very interesting topic, gender and sexual orientation. We are all so very eager, Honorable Justice Kate or Reagan, because insofar as the domestic experience is concerned, we are all, most of the time we are informed, but we look with a great, of course in the age of internet we come across the judgment of abroad also, but then the first-hand account of the experience from a judge is really most welcoming, and we all look forward to the presentation of Justice Reagan.
Thank you very much, Judge Misra, and I think the remarks you've made indicate why I think Chief Justice McLaughlin of Canada said that equality is definitely the most difficult right. And I think I will be able to illustrate that in the context of the South African experience as I go along. Perhaps it would be useful for us all just to get a bit of a sense of how we're going to work our time, because it's 4:10 now, and I think we're due to finish at 6. I was scheduled to have half an hour. I'm happy to reduce that, but I think it would be useful if we could all get a bit of a sense of where we're going time-wise.
You have so you have about 45 minutes. We'll stick to that. Maybe
I won't need that long, but I'll try and abbreviate it because I think it would be useful. I think I can. I think it would be useful to have some conversation. Then I'll try and work to a sort of 20-25 minute deadline, and then that will give us time for the other speakers as well. Good. I'm going to make a couple of preliminary remarks, and then I'm going to tell you a little bit about the South African context, because I think as we've understood, and some of the discussion we've already had, has illustrated how contextual equality is, and I think it would be helpful for you just to have a bit of a picture of the South African context to go on. Then and I'm afraid I always find it difficult, the academic in me always rears its head. I'm going to talk a little bit about the concept of equality, because again, I actually think equality, perhaps more than any other right in a Bill of Rights, is driven by philosophical understanding and a purposive understanding of what we think about equality. And then I'm going to talk about our Section 9. South Africa, of course, is a newcomer to the block. Our constitution stems from 1994 and 1996, complex story why it's 2 years, but I'm going to look at Section 9 of the South African Constitution, which you'll find in this rather voluminous pack. I've been thinking about my luggage going home as each one has arrived, but in the voluminous pack you will find the very first page. It's got really the only thing you need to look at, which is Section 9, the Equality Clause. And I'll just go through that and talk to it. And then finally I'm going to talk briefly about gender and sexual orientation in the South African constitutional experience. The preliminary remark I want to talk about is a little bit about the problems of the comparative method. because our constitution says that we must look at international, we may look at other jurisdictions, and indeed we regularly look at India. And we regularly look at jurisdictions around the world, Canada in particular, to some extent the United States, Europe of course very extensively, and then our neighbours, Namibia, Tanzania, Kenya. So what are we doing when we're looking comparatively? Why should we want to do this? And I think we have been alerted to the difficulties of this perhaps by the rather intransigent attitudes of some members of the United States Supreme Court, but I do want to suggest that there really is a problem here, particularly in the context of equality, which is that if something is based on context, then any kind of free borrowing without real understanding of context might well be quite problematic. And I think therefore the value we get from the comparative method in equality is not so much the pulling out of some of the beautiful words of a colleague from another jurisdiction, but beginning to understand where our own blind spots are. And I think we've already seen a little bit of that this morning. There's, I think, a relatively polite urging coming from some Indian colleagues to say, well, the way we think about equality is different to the way you think about it in Europe, and we think there's some good reasons why we think about it like that. And I think those sorts of debates that occur under the comparative method are the most valuable things. It's not really helpful to just cherry pick from judgment to judgment. So I'm not going to suggest to you that the South African approach is one that should be adopted in India or should be adopted in Europe, but might make you able to think a little bit about your own system and your own way of doing things, and whether, the way I explain our experience might just sort of have an open mind moment, which I think for judges is always a good thing, and I know barristers generally think we never have it. But I think that's the idea of the comparative method to me, is to encourage that open mind moment. Right, turning to the South African context. South Africa is a middle-income developing country. Our GDP is $144 billion, and more interestingly enough, we have a per capita GDP of about $3,000 compares to India with a per capita GDP of somewhere between 1,000 and 1,200, and not quite sure what the UK is, but considerably in excess of that. But it puts South Africa very firmly in the developing country context, in middle income. We're a population tiny by comparison to India. There are 50 million of us, and of course we are very diverse. Between 75, we haven't had a census since 2001. We're just like see India's about to have their census. We're also about to have ours. But in 2001, about 77% of our population were African of descent, black African from, as opposed to our Khoi population, but black African South Africans. We have a population of 1.2 million people of Indian descent, and by and large, our population of Indian descent came to South Africa in the late 19th century as indentured labour to work on the sugar fields, and most of them stayed. We also have a proportion of people who came over as traders. Accompanied that, of course, Mahatma Gandhi came and spent some formative years of his life, and certainly for South Africa, in South Africa, around about that time, the early 20th century. We have 4.3 million of so-called coloured descent, and that, in fact, includes within it original inhabitants, Khoi original inhabitants, also referred to as Hottentots and Bushman inhabitants, as well as the descendants of slaves who were brought in the 17th century largely from Malaysia and Indonesia. And a very large proportion of those live in the city where I live, which is Cape Town. And then finally we have a white population of about 4.5 million, so just under 10% of the population. We speak 9 official languages and several others, including Gujarati, which is in fact mentioned in our constitution as remarkably, even though only 8% of us would in fact be first language English speakers. So there again, quite a similarity, I think, to the Indian experience. We are religiously diverse, though less so than India. Probably about 80% of us are Christian. There are significant Hindu, Muslim, and Jewish communities, so Jewish communities now shrunk and become very small, as well as African animist religions. We are, by international standards, again, rather like India, a very religious, and yet, also rather interestingly, it produces very little conflict in our society. We have the suburb where I lived in Johannesburg when I was a member of the Constitutional Court, was probably the only suburb in the world where within a couple of 100 meters there was both a synagogue and a mosque, and the communities lived side by side, and then there was I in the middle of a sort of agnostic ex-Irish woman. So very, very diverse, and religion is just not, it's not a touch point in our society. Race, of course, is. We are very unequal. Our Gini coefficient is arguably placed somewhere between 0.6 and 0.7, where, as you know, 1 is perfectly unequal and 0 is perfectly equal. We are deeply, deeply unequal. Nearly 50%, again, like India, nearly 50% of South African households are poor or very poor and are living close to the poverty line. The depth of racial inequality reached its height in the early 1990s. Now what we're seeing is that there's a slow reduction of inequality between the races and a deepening of inequality within a race, which illustrates that what's happening is some African people in the Indian community are moving into the middle class and upper middle class, so you're getting patterns of inequality within those groups and a slightly declining pattern between races. But still, and the fundamental reality of South Africa is deep inequality. Of course, this inequality is a direct consequence of both several centuries of colonialism and very damaging half-century of apartheid. And our Constitution expressly seeks to remedy this. It says in its preamble, which we use a lot in our jurisprudence, that the Constitution seeks to heal the divisions of the past and to establish a society based on democratic values, social justice, and fundamental human rights. That's a very clear vision, I think, for both interpretation of the Constitution itself, but also for statutory interpretation. And a little bit, as Judge Sikri was saying, we use that a lot in our method of statutory interpretation. So that gives you a bit of the picture of the South African society. Turning then to the philosophical and conceptual issues around equality. The idea of equality as an enforceable right is, of course, a very modern idea, although the historical genesis of equality as a philosophical concept is ancient. So we've really only been grappling with equality as a modern right. I think probably, arguably, you could say since Bravo's Board of Education. Could go back a little bit before that. In some other jurisdictions you might find cases here and there, but it's a past the middle part of the 20th century, I think, is when we started working with it. And of course, again, as Judge Sikri also mentioned, it's rather simple to state, and it goes right back to Aristotle, as he also said. Persons who are equal should have assigned to them equal things, and like should be treated alike, but unlike should be treated differently. The principle itself, of course, holds out an enormous amount of promise to those people who have been routinely discriminated against. So it's one of the reasons that it has enormous political power, both, I think, well, certainly in South Africa, but I think right across the globe. Whether you think of apartheid, and although they're not the same, I think the idea of indirect discrimination as it's developed in the UK and Europe, and the adverse impact jurisprudence that's developed under the Title VII of the Civil Rights Act in the United States are both forms of reacting to the shortcomings of equal treatment. But there is, interestingly, sometimes a tension between them, and that was illustrated, I thought, very interestingly in a case which became very famous during the confirmation hearings of Judge Sotomayor in the United States. The case is Riki versus De Stefano. And in Riki versus De Stefano, it was a case about hiring firefighters in the town of New Haven. New Haven is, for those of you who are academically minded, the home of Yale University. But as well as being the home of one of the wealthiest universities in the United States, it's also one of the poorest cities in the United States. Its population is 60% Hispanic or African American and has probably a very, very high Gini coefficient in the town. And how they set the application routine for firefighters was they set a test. And it turned out that of all the applicants, large numbers of whom were African American and Hispanic, only 2 of them passed, whereas every single white candidate passed the test. And the union on behalf of the Hispanic and African American candidates challenged the test as being as having indirectly discriminatory. It was excluding people for reasons that were not relevant to the task, but was having this impact on keeping Hispanics and African Americans out of the firefighting force in New Haven. Who had passed challenged the setting aside on adverse impact grounds, on the grounds that they were not being treated equally because they passed the test and they ought to be allowed to get the job. the interesting thing about this case is it does illustrate, I think, quite sharply this tension between equal treatment on one hand and impact on the other. And I think somewhat alarmingly, Judge Scalia, in his judgment in the case, said this case presages a war between equal treatment and disparate impact, which will have to be waged. And you may know, those of you who follow US jurisprudence quite closely, that the diverse or unequal impact, diverse impact approach has never been adopted under the 14th Amendment. It only applies under Title VII. And really what Judge Scalia was saying in Di Stefano was, is Title VII's approach to diverse impact consistent with the Constitution? And it's a, as I say, slightly alarming dictum. But it seems to me that having illustrated all of that, I still think we're working the ground here. I don't think we actually have very clear answers to equality at a high level of abstraction. Although it is true, I think, that most jurisdictions now recognize the shortcomings of equal treatment, a full, sustained analysis of diverse impact and of the approach to equality still, I would say, eludes us. And I think that we may well have other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. That's what is called loosely affirmative action clause, restitution equality. A couple of interesting things to notice about it. Firstly, it's not seen as an exception to equality. It's seen as the promotion of equality. And that really comes down to this understanding that the purpose of the equality clause is to try to remove patterns of disadvantage which run along group lines in our society. A very big challenge in ours, as it is in many. But that steps that are taken with that purpose in mind are not considered to be an exception to equality, but part of a program to promote equality. Another thing to notice is that it hinges this not on race, tempting as race would have been in the South African context, but on the notion of disadvantaged by unfair discrimination. So it's hinged on the notion of disadvantage. And that we could have an interesting debate in the sense, and we've watched with some interest your jurisprudence around creamy layers, as it's called. The idea here is that in a sense, the target of it should be people who are disadvantaged. The fact that you can't always target very accurately is neither here nor there, but the target should be people who are disadvantaged. We've really only had one case on this, which is also an interesting indication of how uncontroversial this is in South African life. Or put it this way, how uncontroversial the likely legal outcome in cases is in South African life. And that was a case around a pension system for parliamentarians. And the court said that although we acknowledge that at times programs under 9.2 may be harmful or cause some harm to people who are formally advantaged, that is acceptable unless the extent of the harm is such that it is materially likely to affect them in their sense of dignity. So any complete prohibitions on white South Africans, I think, would be very likely to be problematic here. There's also clear focus in the court's jurisprudence on the notion of what is likely to be able to undo the pattern of disadvantage. So educational programs, very unlikely to be challenged under 9.2. And if you're interested in this, there's a very interesting live debate happening at the University of Cape Town online about their admission program, which is an admission program which is based on a point system based on your school leaving examination. And it's more or less uniform across the board that for a white student to be admitted, they have to get 10 more points than if they're a black student. That's a simple. And it's an ongoing, it's controversial, and it's an ongoing debate within the university. One of the well-known professors of philosophy is very opposed to it. But the debate is online, students participate in it all the time. It's a pretty vibrant conversation, which I think is very valuable. I think the university is constantly reviewing it to think about how best to deal with it. But it does illustrate that that there is an acceptance that we need to do something to undo this deep inequality, which still does run along race lines. Paragraph 3, which is really in many ways the workhorse of our equality clause, is the unfair discrimination provision. The state may not unfairly, interesting word, discriminate directly or indirectly, borrowing directly from the UK and European experience, against anyone on one or more grounds, including, not a closed list, race, gender, sex, pregnancy, marital status, ethnic or social origin, colour, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. So a very long list, but not a closed list. And the court has taken the view that other grounds may be added to the list if the effect of discrimination on that ground is likely to impair the dignity of people living, of people who have that particular quality, or harm them in some comparably serious manner. And the ground that has been added, most notably, is HIV/AIDS status. So people living with HIV/AIDS status are considered to be, if you discriminate, the case was a case where the national airline refused to employ air stewards and stewardesses who were living with HIV/AIDS, and that was overturned in our court as being a listed ground, or should be a listed ground, treated as if it were a listed ground, and an impermissible ground for excluding people from employment. But it just gives you an idea that this list will grow. Fourthly, and this is very interesting to me in light of what I learned this morning about India, no person may unfairly discriminate directly or indirectly against anyone on one or more grounds in terms of subsection 3. It's what we would call a direct horizontality provision. It binds individuals and corporations. But it goes on to say national legislation must be enacted to prevent or prohibit unfair discrimination. And we have a piece of legislation not as voluminous, I immediately add, and perhaps therefore not as thought through. Look first at the legislation, not directly at the constitutional rights. And that's really because the legislature's got an obligation to give effect to these rights. And if they do so in a detailed, careful, thoughtful way, litigants should launch their case through that legislation. If there's a shortcoming in the legislation and a litigant says, well, the Equality Act doesn't cover me, they can challenge that piece of the legislation for being under-inclusive, or arguably they can come directly. That's not a determined matter. So if there's a lacuna, a gap in the legislation, you can either challenge it or come directly to the court, yet to be decided by the court. But otherwise, if you are covered, you must bring it under the Act itself, which will then be interpreted consistently with the clause. And finally, discrimination on one or more of the grounds listed in subsection 3 is unfair unless it is established that it is fair. This is an onus provision, effectively, though it's slightly loosely called onus because obviously in our system, as I'm sure in yours, onus generally deals with facts, where the question of whether something is unfair or not is less a factual question, but facts are wound up in it, but also a legal question. But there's a presumption of unfairness. If you can show that discrimination is on the grounds of race, or gender, or age, or whatever, then the person, generally the state, seeking to establish that the discrimination should be accepted, must establish that it's not unfair. So that's our equality clause, and from that you can see that we have drawn very heavily and very usefully on approaches around the world. The leading case on equality I actually haven't given you because, although it's an interesting case, it's cited in every other case on equality. It's called Harkson versus Lane, and you'll find it referred to in the pack. But the court there sets out the approach, and particularly the approach to this question of what constitutes unfair discrimination. And the important point to note there is that the court takes an asymmetrical approach. In other words, something will be unfair if it harms an already vulnerable group, a group that has been disadvantaged in the past by unfair, much more easily than if it harms a group that is already advantaged. And that is a complete move away from a formal equality approach. But it means that therefore if something is harmful on grounds of race to black South Africans, they will find it very much more easy to establish it's unfair. The state will find it much harder to prove it's not unfair than if it affects white South Africans. And the same on gender lines. Women will find it easier to establish unfairness than men. Why would you say we would do that? We would do that because the purpose of equality is actually, in the approach of the court is to try to remove these patterns of inequality that have arisen as a result of centuries of racial discrimination and of gender discrimination. And if we just treat everybody the same, very often you will find, it was interesting, in fact, I thought this morning, Judge Carmen, you mentioned that many of the cases before the European Court of Human Rights on equality are brought by men. That's actually, I think, quite a worldwide phenomenon. And that our view has been that what you don't want to do is, in fact, allow people already advantaged to be further advantaged or to undo legislative purposes which are trying to undermine that too easily. So it's an interesting and I'm quite sure not uncontroversial approach. Turning finally to the last section, which is to talk about sexual orientation and then to talk about briefly about gender. Like the Delhi High Court, the very first case that the Constitutional Court faced on sexual orientation,
The courts in South Africa was giving utmost importance to constitutional supremacy than the constitutional rights, if I've understood you correctly. So I think that, of course, is innate in all judicial actions. So now, without taking much of your time, I would invite Professor Tom O'Connell, to whom we look forward to give his presentation on discrimination on the grounds of race. So, Professor Collins.
Thank you very much. I'm delighted to be here. I am scheduled to talk about race discrimination, and in particular to sort of talk about race discrimination from a European, UK perspective. I am lucky among the speakers because much of what you will have heard this morning covers some of the material I was going to look at. And that means I'm going to try to keep my contributions fairly brief and fairly focused. Lord Walker this morning used a cricket metaphor. He compared himself to an opening batsman. That makes me a batsman at the tail end who thinks the job of his team is done by those who came at the beginning. So I'm going to come in, bash a few ideas around, and not stay for very long. Right? The race discrimination is unusual unusual within the framework of public international law, because race discrimination, both as something that is recognized as morally bad and as something that is recognized as something that should be prohibited by international law, is widely rejected across the world. The Convention on the Elimination of Racial Discrimination, CERD, is, I believe, the most ratified UN Human Rights Convention. I think it has more ratifications than even the 2 UN major human rights covenants. All across the world, governments and states are very clear that they do not practice race discrimination and that they disapprove of race discrimination. However, it's very easy to state that in general terms. But actually, as we've seen today, turning that general value and applying it in concrete, difficult circumstances can be a very, very difficult exercise. We heard this morning about the problem of cascading inequality, where you can have accumulating or overlapping forms of equality, where someone's race can interact with their gender, their social class, their religious background, their age, disability, and other factors to create, if you want, layers of inequality. So that a person in one individual circumstance may not be particularly exposed to racial discriminatory treatment when someone of more or less the same ethnic origin as themselves might experience things in a very, very different way. More problematically, race discrimination is often thought of as something that other people do. You know, we have unusual social practices, you are dreadful discriminators. It's often the case that the deepest, most entrenched problems of race discrimination are precisely those problems that seem common sense, are precisely those attitudes or those assumptions that appear common sense, are normal, are okay, are well established. So in other words, it's one thing to speak about race discrimination being bad in a very abstract sense. It's another thing to operationalize that and make it effective when it comes to concrete legal rules. Different countries deal with the problem of race discrimination in different ways. When it comes to law, they usually make use of 3 different types of legal approach. And they often usually use a combination of all 3 different types. Firstly, countries sometimes use criminal law to deal with the problem. Criminal law can often be extremely effective at banning certain types of racist behaviour. Interestingly, however, historical experience since the Second World War has shown it can be very ineffective at dealing with very deeply rooted problems of discrimination. In the 1950s and 1960s, Britain and France carried out, without consulting each other, a very, very interesting socio-legal experiment. Because Britain emphasised banning discrimination using legislation, by making discrimination effectively a wrong that should be remedied through civil law. France thought this was a bit weak and went down the line of banning discrimination through the criminal law. It's stronger, it's tougher, and so on. The problem is, as we all know, it is often much, much more difficult to secure a criminal conviction than it is to pursue a case through the courts through civil means. Furthermore, the willingness of state authorities to take criminal cases can be a serious problem. The results of the experiment between Britain and France, 2 very similar countries in many ways, very different countries in other ways, but the results of the experiment have been quite interesting, that the French criminal law isn't particularly effective. And the French have subsequently, as with all European countries, since the European Race Equality Directive of 2000, introduced something more like the UK legislation, or the US legislation. Around 15 years ago, there was, I think, 100 criminal cases of anti-discrimination, of race discrimination in France, under criminal law alone. Last year, there were several thousand civil cases. So civil law, using civil legislation, is often a more effective means of dealing with discrimination in many countries than using criminal law. And constitutional norms are, in a country with an unwritten constitutional system like the UK, something like the UK's Human Rights Act, is often extremely important in fighting race discrimination. It establishes very strong symbolic statements of national law. It binds public authorities, it binds the state, and of course it has huge overarching normative power and legal power. But of course,